we should undoubtedly understand that it's looking at the people at the top end that's the only thing of real importance at the moment. That's not to say everybody and anybody else, however far down, should not in some way and at some stage be tried if there's evidence against them. That's a different question. What we absolutely need to have tried now is the leadership.
Ukraine's chief prosecutor has said that these trials are sending a clear signal that every perpetrator, every person who ordered or assisted in the commission of crimes in Ukraine shall not avoid responsibility. But many are now asking, could President Putin, generals or other leaders be prosecuted, and what challenges stand in the way? Sir Geoffrey Nice is a leading human rights lawyer who successfully prosecuted the Serbian president Slobodan Milošević. Milosevic was accused of 66 counts of genocide, crimes against humanity and war crimes committed in Croatia, Bosnia and Herzegovina and Kosovo between 1991 and 1999. Sir Geoffrey, I bring that up, but are there parallels? I mean, the prosecutors are currently focusing on individual soldiers, which seems at the completely opposite end of the food chain, if you will. In the case of the Russian tank commander who pleaded guilty yesterday, prosecutors say he was ordered to kill the civilian. So don't we need to be looking higher up the chain of command?
Yeah, one correction. We don't know if I prosecuted Milosevic successfully because he died before the end of the trial and no verdict was returned.
I'm an eternal optimist and I think you would have been successful.
As to your question, it's a very important question. And my answer is we should undoubtedly understand that it's looking at the people at the top end that's the only thing of real importance at the moment. That's not to say everybody and anybody else, however far down, should not in some way and at some stage be tried if there's evidence against them. That's a different question. What we absolutely need to have tried now is the leadership. And that shouldn't be a very difficult trial, more or less admitted as to what his intention was, which was a war of aggression, although at the moment you can't try the crime of aggression. And as to the individual acts that were manifestly crimes against humanity from the very beginning, then of course he's guilty of those, not just because he might have instructed them, but as soon as he knew about them, and he knew about them the same night because he watched the same television as the rest of us, then why didn't he say something? Why didn't he say, I don't instruct that these civilian houses should be destroyed? Why didn't he say, I'm calling back the commanders who did that? Well, the reason he didn't is because they were doing what he wanted them to do, either because he'd specifically instructed that their conduct of war should be without limits of the Geneva and Hague Conventions, or simply because he created an environment whereby his commanders knew that working towards him in the way that people were said to have worked towards Hitler.
Is there a crime of silence then, as well as a crime of orders?
Well, I'm not sure quite what you mean by silence, but if you mean is there a crime involved in doing nothing when you are the person who has the power to stop something? Yes, of course there is. Because if you look at exactly what I've said, you create an environment where your people are going off to commit crimes and you know they're going to do that. You're the only person who can stop it. You become complicit, completely complicit in their crime if you do nothing. Indeed, it can properly be inferred from your saying and doing nothing that you wanted that to happen. Indeed, that you may have instructed it to happen and just chosen to hide the paper trail. Can we
take a look at the actual mechanisms in place then to do this trying? I mean, there are two key courts that have roles upholding the rules of war, the International Criminal Court and the International Court of Justice. Maybe you could explain for us how these function and why focusing on Russia, the country, could pose difficulties.
They're very different courts. One deals with breaches of treaties and is not a criminal court. That's the International Court of Justice. The treaty, the most obvious treaty it could deal with is the Genocide Convention. Indeed, that convention has already been raised by Russia against Ukraine, and there have been hearings brought by Ukraine within the context of that overall hearing, going to show that it is not genocide. However, that is not a criminal court. And at the end of any successful genocide hearing, the most you would get is an order that there should be compensation, which might or might not be honoured by the country concerned. The other court, the International Criminal Court, is international, but only to an extent, because only a small part of the world is actively committed to it. However, enough of the world is committed because Ukraine has accepted its jurisdiction that the present prosecutor, Karim Khan, who is investigating the matter, can bring proceedings against individual soldiers and others, and in individual politicians such as Putin, in respect of crimes of war and crimes against humanity committed in the course of this conflict. And as I've indicated already, the evidence that there's been crimes against humanity is absolutely overwhelming, and the case against it is pretty well straightforward. And I think it's very important, two things, if I may. It's important to stop commentators, in particular lawyers, who by and large probably make money by cases lasting longer than shorter, to stop them saying that these trials need to be long and are complicated. They don't need to be long, they can be short. The second really important point is that trials of leadership that are quick and decisive are immensely valuable. Trials of everyone else, the thousands of people who may have committed crimes running into decades, may be helpful in individual cases, but they may be very unhelpful. And that's because a clear determination in a short period of time, where moral right and moral wrong should be found, allows the countries on both sides to move forward. And this is what happened after World War II.
You say they can be short, they don't have to be long. I think that when you were trying Slobodan Milošević, I think it ran from 2002 to 2006, and he died during the process, which might explain why you'd prefer brevity. But clearly establishing a chain of command is a common problem with war crimes. How did you manage to prosecute Slobodan Milošević?
Well, 4 years, in fact, only 2, because we sat half time, only half days, and he was ill a great deal of the time. And of all the prosecutors at the Yugoslav tribunal, I did more than anyone else to try and introduce reforms that would make matters quicker. I didn't actually succeed until it was too late in some respects, and not at all in others. Milosevic was also a very different case, because Milosevic was president of Serbia, and Serbia was not at war with anyone else. So of the 3 wars that were incorporated in the indictment against Milosevic, Croatia, Bosnia, and Kosovo, we had to prove his engagement. Now, in the first 2 wars, he was an outsider. Those were, in one sense, the most important wars. The last war, Kosovo was part of Serbia and was thought by many to be much easier to prove. But looking at Bosnia, which in my view was the critical and most wicked part of those terrible wars, he was an outsider. So we had to prove his role by proving what communications he had with the generals of the Republika Srpska, as it became, the Bosnian Serbs in Bosnia. We had to prove what communications he had with them, what command power he had over them. And interestingly enough, here, although we did find and get and were able to produce to the court some very, very important documents that showed his measure of control, there was political interference, which was effective by dint of the attitude taken by the prosecutor, Mrs. Del Ponte. There was political interference with whether those documents could be made public to the public at the time, an astonishing thing. There was also political interference with other evidence that would have shown his control, and that political interference, to everyone's surprise, you might think, came from outside, from the United States of America and countries like Great Britain, who didn't want the full truth to be told. So when you say, how do you prove command and control in a regular state, like, for example, a regular war, like in the war or the civil war, as they would have described it, between Kosovo and Serbia, you should have the documents, the minutes of meetings, and as well as viva voce evidence from commanders who were spoken to by Milosevic. And that proves, or can be used, to prove the chain of command directly. Where you've got something like Milosevic operating outside a particular country, it obviously becomes more difficult. In the case of Putin, this is a straightforward conflict where he gave instructions via his top generals down to the commanders on the ground, and the puppet strings will be there. One of the most interesting...
Can I just ask you finally, sorry, because we're just about to hit the news. What are the learnings that you would say? I mean, you say that you achieved some of the things you wanted to achieve change with and not others. What are the learnings you would take from your experience with Slobodan Milošević in order to expedite some form of justice here as quickly as possible?
Don't rely on the common law system of law that was imposed on these courts as an act of cultural imperialism by America, England, Australia, and other countries. Look for a quicker method of justice. Look at how journalists, for example, deal with evidence. Journalists got the right answer on Srebrenica by October 1995. The courts are still undecided on many issues 27 years later. Look at the possible process of investigation. Give to the judges a much more hands-on role of deciding what they really need to hear and what they can take in writing. Do not be bound by old-fashioned systems that will be looked at in centuries to come as completely absurd and out of date. We live in an age of documents, and I saw one of the questions your researchers asked me to consider, things being taken with people's cameras and so on. All that material is available, and we should be able to deal with it quickly, and we can if we put our shoulders to the wheel.
And you're actually living the dream, as it were. I can see you waving your smartphone there. So thank you very much indeed, Sir Geoffrey Nice. Thank you for joining me here on Times Radio.